Good morning, everyone. I hope all is fine. I will be continuing some of the items that were left heard of probably by some of you, which is part of our course. Now, more particularly for the remaining weeks of our course plan. Now, the two other elements of a law is that it must be laid down by a legitimate authority for the common observance and benefit. Now, the legitimate authority, as you may recall in our previous discussion, simply pertains to Congress. Now, our government is divided into the executive branch, the legislative branch, and the judiciary. The legislative branch is the one that makes the law. The executive department is the one that enforces the law, and the judiciary is the one that interprets the law. So with respect to the law, each of these departments in our constitution is tasked to perform these respective assignments. Now, with respect to lawmaking, if you read the Constitution on the legislative department, you will see that these laws are generally subject to 3 readings. The first reading pertains to the plain reading of the title. The second reading would be the reading that is undertaken by the appropriate committee who will be endorsing it for second reading. And in this reading, this is where interpellations are to be made. This is where a law is being critiqued. And the third reading would be the generally the last reading before a particular chamber would approve the bill. Now, take note that when Congress conducts these processes, this process of lawmaking is undertaken separately by each of the by each of the chambers. When you talk of Congress, you don't only talk of congressmen, but you talk of the Senate as the upper chamber and the House as the lower chamber. It is not right to say that one is higher than the other. Neither is it proper to say that these two chambers are different, because in a sense they have similarities, and in some sense they also have their differences. But for purposes of lawmaking, a law is or passes the 3 readings separately for each of the houses. One of the differences is that one house would normally have the prerogative. Each of the house would normally have generally the prerogative to hear what particular law they want to hear, except that when it comes to tax measures, the Constitution expressly provides that it has to originate from the lower house, like franchises. So you will recall that in the case of ABS-CBN, it has to be heard by the House of Representatives first. And since it didn't progress, it never reached the Senate. So, what happens then if a particular bill, which is a proposed law, undergoes these three readings? Is it enough to say that this bill uh, may now be considered as a law? Are the three readings enough? Now, as I said earlier, while the lower house and the upper chamber might seemingly be independent of each other, but they are likewise interdependent, because when it comes to the final determination of the appropriate bill that is intended to become a law, there is actually this fourth process whereby this bill that succeeded in its third reading in the respective houses will be brought. And this is not really a fourth chamber, but informally they refer to this as the fourth and most important chamber. This is actually the Bicameral Conference Committee. Now, every Congress has its own committees, but they are all the same committee. Like, for example, if it involves a law that pertains to criminal statute, then it's the Justice Committee. So there's a Justice Committee in the lower chamber and a Justice Committee in the upper chamber. And there is also a Bicameral Conference Justice Committee. Now, this Bicameral Conference Committee, they say, is a very strong or powerful committee. Why? Because the main task of the Bicameral Conference Committee is none other than to reconcile whatever conflict there may be with respect to the version of the lower house and the version of the upper house. Now, you will again recall that one of the most controversial statutes that is being heard now in the Supreme Court is the Anti-Terror Bill. Now, in the version of the Anti-Terror Bill proposed by the lower chamber, there were numerous questions as to some of its vagueness and some of the possible abuses. Now, when Congress passed their own version, it has a different there are differences between the two, and as declared by Senator Lacson, he assured the public that with respect to the Senate, they will ensure that there will be enough safety nets. And so, when the bill was articulated in the Bicameral Conference Committee, the final version provided some of the items, if not all of the safety nets that the Senate introduced. And this is the one that is later on submitted to the office of the President, which became an enrolled bill and which later on became the basis of the President to approve. So, once the bill is or passes the Bicameral Conference Committee, then it will now be transmitted to the office of the President, and there are three ways by which a bill may become a law. What are these ways? First is if the President approves it, then there's no question. The second one is if and when the President does not do anything. So if for some reasons the President slept for 30 days, figuratively, and the law then is deemed approved by the President. In other words, a bill has to be expressly disapproved if it shouldn't be approved. Otherwise, by operation of law, it becomes a law. And the third and finally is that if a bill is disapproved by the President, Congress voting separately may override the veto power of the President by 2/3 vote. What's a veto power? It's the power of the President to disapprove. Now, can the President do an item veto or simply veto only portions of the law, or rather the proposed law? Now, the answer is, as a rule, the President cannot resort to item veto. It's generally a package deal where the President may either approve or disapprove. The exception, however, is with respect to tax measures. In these particular instances, the President may just choose some provisions that it thinks may be disregarded. So that is called an item veto, and President can do that with respect to these types of bills. Now, if and when this bill is approved by the President in any of those standards that were mentioned, the next question would be, would this bill now, or rather, will this be law now? Can this now be enforced? Or, simply put, is the law effective? Which brings us to the fourth element, that laws are intended for the common benefit, no? And observance. Now, in other words, before you can observe the law, we have to assume that the law is already effective. Now, the question is, when do laws take effect? Now, I invite your attention to the case of Tanyada versus Tuvera, which was an offshoot by numerous laws that President Marcos, quote-unquote, legislated. Well, during the time of the martial law, the President had that prerogative to act both as an executive department and as Congress, because by a mere stroke of a pen, he can legislate. And even up to this date, you will see a lot of presidential decree, PDs. Now, presidential decrees they have the force and effect of laws. As mentioned earlier, there are different types of laws. You have batas pambansa, you have presidential decrees, you have even some, to a certain extent, executive order. These were under the time of Cory Aquino. And presently, you have Republic Acts, no? Which was also the time of Cory Aquino up to the present, or the laws that were under the 1987 Constitution. Now, what's the relevance of these laws? These laws reflect the period by which they were legislated. But as you well know, laws, as a rule, are not self-expiring. So laws may either, as long as they are effective, as long as they are good, they continue to be effective. Later, when you go to statutory construction, you will see that at some point, subject to highly exceptional cases, there are laws that if by lapse of time it is no longer useful, or the purpose ceases to exist, that's the time that the law can be later on declared as abrogated. But as a rule, there's no expiration for laws unless the law itself provides for its expiry. So these laws, so they reflect the period by which they were legislated. And during that time of former President Marcos, there were those who challenged his laws because he invoked Article 2 of the Civil Code. And if you read Article 2, it simply says that laws shall take effect after 15 days following the completion of their publication in the official gazette or etc. Later on, Cory Aquino, through executive order, included newspapers of general circulation as a mode of publication. Now, uh, in in utilizing this provision, the President Marcos says that since there's a term unless otherwise provided, they interpreted it to mean that unless the publication can be dispensed with, then the laws can be effective. That's how they saw it. So this was challenged by former Senator Tanyada, the old Tanyada, or the better Tanyada, as some may say. Um, how did the Supreme Court resolve the case of Tanyada versus Tuvera? Of course, based on your reading, and presumably you read them, the Supreme Court had to correctly interpret it and uh, just the same declared laws that were preemptively declared as effective are still valid because political exercises have been made over these laws. But to guide the bar and the bench and the public as well, the Supreme Court interpreted this provision of the Civil Code to the effect that laws, rather to the effect that publication is an indispensable requirement of before making a law effective. Now, why is it an indispensable requirement? Well, the Supreme Court said that in the interest of due process, people has to be made aware that a law is existing. That's why the complete publication is one that is required. So, in other words, before a law can be made effective, it has to be completely published. Now, you will please take note that in recent times, whenever there's a new law that is being implemented, you will see that they say that we will first, like for example, with respect to regulations on or traffic regulations and the like, they would first come up with the 6-month trial period before strictly enforcing it. Why? Because this has to meet the standards in Tanyada versus Tuvera, where complete publication is necessary. Now, so if you'll be asked, when do laws take effect? I am 101% sure that even when you go to law school and you study civil law or obligations, probably persons and family relations, or even obligations and contracts, the first question that will be asked of you is when do laws take effect? So how would you respond if you will be asked when do laws take effect? You can respond in this way. When do laws take effect? The effectivity of law primarily will depend on a particular law itself. If that law provides for a period of effectivity, that period of effectivity will govern the effectivity of that law, provided further that complete publication is met. For instance, if a particular law provides that it shall take effect after 1 year from completion of its publication, then it will take effect after 1 year of completion of its publication. However, if the law provides that it will take effect, if the law does not provide for a particular date of effectivity, then the general clause in Article 2 will apply, in which case such law shall take effect after 15 days following the completion of its publication in the newspaper of general circulation or official gazette. In which case, the effectivity of the law would now become would now take the law shall now take effect after 15 days or on the 16th day. So if the law was completely published on December 1, so what would be after 15 days? So that would be the 16th day or after the 15th day. So you exclude the first day and then include the last day. So January 1 siya for example completely published. So January 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. So on the 6th on January 16, the law can now be considered as deemed effective. Now, how important is this? How important is the effectivity of laws? Now, this is very important. We learned earlier of several principles. For example, the principle of nullum crimen nulla poena sine lege and the principle of ex post facto law. Unless the law is effective, you cannot really seriously say that it has to be enforced. Now, you recall what happened to Senator Coco Pimentel, who was charged with or who was condemned by the public because he went to the hospital knowing that he was actually subject of he's a person of interest because of COVID. Now people were saying that he violated the Bayanihan Hilas 1 Act. But sadly, however, the Bayanihan Hilas 1 Act was not yet fully published in the official gazette by the time that he seemingly violated this law. So, strictly speaking, he can be sanctioned or penalized under the Bayanihan Hilas 1 Act. But he can be penalized under a different law, and that is now the subject of contention. So the date of effectivity of law is very important because unless, as I said, unless the law is enforceable, it cannot be and should not be invoked. However, in some instances, there may be exceptional cases where this rule may somehow be relaxed, and more often this is found under international law. And last time I asked you to browse the Nuremberg Trial, and in the Nuremberg Trial, you will see that this was the first time that the International Criminal Court was constituted, and this is also the first time that the concept of violation of human rights, among others, have been introduced. No, crimes against humanity have been introduced. And if you will be strict about it, at the time that the Nazi officials committed these acts, no, these weren't available yet. But in the highest interest of justice, and probably following the Machiavellian principle, they opted to still proceed, no, despite the challenges. And of course, history will now tell us that this is really one of the very interesting international proceedings ever made. So, but insofar as our domestic law is concerned, we will strictly adhere to this rule that you cannot enforce the law unless it is made known. Now, aside from those mentioned, I also invite your attention to the resolution in the South China Sea involving the Philippines and China with respect to the enforcement of the UNCLOS. Now, this UNCLOS, as you see, based on what was presented, is also a very interesting milestone. This is a part of international law. And here, equally like our domestic law, if we become signatory to an international covenant, this partake the nature of a law, and this should also be for the common benefit and observance of all the signatories. Now, as you may have seen in the summary I provided on the clause, well, even if China participated in UNCLOS, it ignores the enforcement. Now, this is rather one interesting issue because there's a question as to how this should be enforced. Although it is very basic that exhaustion of all remedies must be undertaken. And clearly, it is not wise to go to war against China. Now, there are many suggestions that are being made to enforce it. One of which is to strengthen the relations with the other nations, so that eventually China might be forced to agree to an international covenant between and among neighboring states as to how UNCLOS should be adopted. Um, but strictly speaking, if only the Philippines would really be would insist on its rightful jurisdiction over that part South China Sea, it can actually, there are many other decisions in the International Tribunal where a country can come up with laws or maritime laws, which can also be a basis to prevent ships from exploring its waters. So what the Philippines can do is probably legislate a maritime law, and then on the basis of that law, even if a neighboring state passes through within the exclusive economic zone, they can apprehend that foreign vessel, just a measure of protection. There are so many cases. In one case would be a case involving Spain. So Spain came up with a measure that prohibits the exploration of its resources, and a foreign vessel entered within the ECC. Technically speaking, if it's within the exclusive economic zone, there is a jurisdiction, but it's limited. Theoretically, it's not a criminal jurisdiction because there is that point that it's already on the high seas, yet within the exclusive economic zone. But still, the country involved can come up with measures, and then on the basis of that, hold the vessel, so that it can tell the universe that well, you're violating our laws. So Philippines can also do that, and I hope that in time they can come up with a commission, you know, to come up with a particular message. I'm not certain if the government has established a commission on this, but in an alternative universe, it would be great to have this type of commission to study this matter, headed by retired Justice Antonio Carpio, in an alternative universe, of course. Let's see what will happen. Maybe the president, before he steps down, realizes its importance. Although, although DFA can actually also do that, no, if only to show the means by which this could really be done. So, guided by the last element, that laws are for the common observance and benefit. Take note that when a law would partly benefit some sectors, does that violate this prohibition? In like manner that, well, this common observance and benefit is actually founded on the Equal Protection Clause, so that laws might or should be applied to all under the same class. So, but if a law would somehow affect only a certain sector of the society and would, strictly speaking, would not be beneficial to all, can you challenge the law for being violative of the Equal Protection Clause vis-a-vis not for the common benefit? Now, while the Equal Protection Clause ensures that laws should apply to all, it does not, however, prohibit classifications. So if there is a substantial classification showing that incidentally the law may only apply to certain individuals or group, then it would still be considered as for the common benefit. Why? Because the Common Benefit Clause or the Equal Protection Clause does not require that everyone in our society will benefit. The public use, so to speak, that is, for instance, enshrined in the eminent domain, that properties taken by the government should be for public use, would not strictly require a direct public use or a direct benefit. Say for instance the Daanghari. This Daanghari, those from the south would visibly see how this Daanghari, it's a road that provided a better way between Cavite and Muntinlupa. In the process, the one who benefited or which benefited in this scheme were the subdivisions of Senator Villar. So that's why if you look at the assets of the lawmakers, Villar is one of those, if not the richest, senator. Now, why? Because his property appreciated. All those properties directly attributed to him. And now it would seem that he purposely entered politics so that he could somehow ensure that this would be done. So in a way, he used public funds to benefit his projects. Now, is this illegal? Well, if we look at the Constitution, the requirement for the Equal Protection Clause, the public use and the like, he did not violate. Why? Because the Constitution does not require a direct benefit. So, in the process, when there is a better road that would link cities in between, this would not only benefit those cities, but it will also benefit the public in general, albeit indirectly. So, the benefit clause uh, does not strictly require direct benefit. It may be uh, direct or indirect. Now, is it moral? Well, not all laws are moral. We just have to submit it to his conscience. No? But the fact is, it is beneficial for all. So even if you just passes or you just pass by these roads, or even if you don't, when transportation is made effective, it surely benefits everyone. Why? Because when this is made, the economy surely becomes equally good for the people, and when the economy is has improved, then I mean surely all will benefit from it. Now, if you have questions pertaining to all of these concerns, you may send a private message so that I could also respond. No. Now, so take note of the other items. No. Take note also that the duty of the state is really for the common benefit of all, for the protection of the people. And through these measures, through law passed by Congress, presumably these are all for the common observance and benefit. Even the anti-terror bill, or now the Anti-Terror Act. No? Now, let us see how the Supreme Court will deal with the propriety of this measure, which has been subject, no, of a number of cases. Take note also of the number of state policies that would really are intended to protect the people. Now, after learning laws in a wider extent, the next question is why is the law, why 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 is it important to study the law? Now I ask you, why is it important? Why are you studying law? Well, of course, primarily, laws are presumed to be known by everyone. When a law is published, constructive notice is hereby taken meaning we are now presumed to know the law. In fact, under Article 3 of the New Civil Code, ignorance of the law excuses no one from compliance therewith. In other words, we cannot say that we are innocent because we do not know the law. However, take note that difficult interpretation of a law may nonetheless be a basis of good faith. But the good faith here, as basis, may only mitigate whatever liabilities they may be in the violation of the law. But the law remains to be effective, the law remains to be respected, any violation should be penalized. Except, as I said, a difficult question of law might be a basis for good faith. Now, although, aside from that, although ignorance of the law excuses no one, if you read the provisions of the revised penal code on exempting circumstances, mitigating circumstances, justifiable circumstances, these are a few of the circumstances that would somehow either absolve a person charged of a crime or mitigate whatever liability there may be. Take, for instance, the case of Pemberton. He was initially charged with murder on the basis of abuse of superior strength, I think. But then again, the not the Supreme Court rather, but the trial court perceived the incident as an impulse killing. So meaning, more than anything else, he did not really intend to or even much less plan to kill the victim, but out of his frustration, upon discovery that what he met and I think made love to on that night was not really a she but a he, and of course well, sad for both parties, no? But because of that, no, probably the court saw that, well, he didn't intend it. He should be some not really forgiven, but so the penalty was downgraded from murder to homicide. So instead of holding him liable for homicide, he was held liable for instead of holding him liable for murder, he was held for liable for homicide, which has a lesser penalty. So aside from that, even the law that was introduced by Senator Pangilinan and passed by Congress, downgrading the criminal liability, the juvenile justice law, no? I think the juvenile justice law, Juvenile Justice and Welfare Act, or Republic Act 1063, downgraded the age of the minimum age of criminal responsibility. So right now, a child 15 years of age or under at the time of the commission of the offense shall be exempted from criminal liability. So here, the provision of Article 3 of the new Civil Code will not apply if you're 15 and under, or a minor. So a minor before is under 18 although right now it's still under 18, but for purposes of criminal liability, a child is deemed not to be responsible for a criminal act. Unlike before, there is a saving clause unless he acted with discernment. Well, I um, I join some of those who critic this law because uh, while in the past, when you are under 15 or 15, you might be perceived as a kid. But the reality now is because of the advent of information technology, a 15-year-old kid is no longer a kid, so to speak. In terms of acting with discernment, he definitely can act with discernment. Uh, in fact, kids these days, no? Yung mga 15-year-old, minsan nga kahit 12, mas madami pang alam sa mga matatanda. So, they can really discern. Now, when do you say that there is discernment? Well, discernment simply is the ability to determine between right and wrong. So, it doesn't take you to be 16-year-old or over 15-year-old to know that for instance it's not right to kill. I mean sadly well, because of the weak justice system that also should also address concerns involving minors, because our justice law should not be mainly intended to penalize but also to reform. But because we do not have those facilities, that's the problem. So under this law, only those between 15 and under 18 may be subject to intervention. So they can be held liable, but they can undergo intervention. But the intervention process, yung mga bahay something, bahay kalinga ba yun, or bahay something, yung mga for these offenders, youth offenders programs, kulang pa rin. So kaya kailangan ng partnership with the private sector kasi nire-reform sila. Pero dapat pati yung mga ibang kumbaga dapat nga binababa kasi madami talagang naabuso. And for example, yung mga drug cases, ang ginagamit na courier is mga bata. So, and then ang papakita lang nila sa police, birth certificate, i-release na dahil nga exempted from criminal liability. This is one of the defects, no, of our law. Now, although in this law there is this Juvenile Justice and Welfare Council, let's hope that this council would be able, consisting of members of many other departments, would be able to come up with better way, no, or even to the point of recommending this the reformation, no? Now interestingly, in this law, well, if the crime committed is a very serious offense like murder and the like, still naman the law would subject a child, no, 12 to 15 to a special facility within the youth care facility. So isa subject pa rin naman siya in this law, pero hindi pa rin siya considered as a crime, so to speak, you know, even if he acts with discernment. So parang siya, ang term sa kanya, neglected child. Well, that may be true, but being neglected is not a justification to commit a wrong, no? So that so much so na yung kahirapan hindi naman sorry, hindi ito dahilan para hindi ka na maging umayos, ano. Um, so these things you really have to consider. Now, why else? Why is law also important? Now, of course, those who'd like to become lawyers, no, studying law is important because this would those who would like to become lawyers, you have to know the law, and of course take note of the requirements for admission to bar or to the Philippine bar, the requirements that you need to process. And I'd like to invite your attention to the recent circular implemented by the Supreme Court. Let me share it with you. The guidelines on the Externship program of law student practitioners in court under Rule 138. So, this is a new rule that was just signed last November 24 and to be effective on January 2, 2021. So, what is this all about? Well, those who'd like to engage in law student practice. So, ito parang lawyer-lawyeran. Yan. The program aims to acquaint law student practitioners with the review of other processes of the court to which they are assigned, etc., ethical standards, etc. Ayan. So they can apply, no? To courts, no? So ito na yung magiging interns ka sa court. So ngayon ina-allow na siya. Pero ito, I think yung mga undergrad graduates or yung hindi law student, hindi siya covered. So kailangan na sa law school ka. Ayan. So this is good, no? Because even the students will be under the supervision of the judge. Ayan. So may mga access din siya, etc. Now, I think this is meant to address the scarcity or rather the difficulty of courts, no? Kasi minsan kailangan ng courts ng madaming staff or court staff. So, yan. So, pwede na kayo mag-intern, no, sa court para ma-expose, no, in law practice. Now, again, if you have some questions, you may refer it to this, no? Now, take note of Rule 138, Section 5 and 6 of the Rules of Court. I'll post it, no? Rule 138, Section 3. Sections 5 and 6, no? This pertains to, I think, the admission of to the bar, which has been amended also by the Supreme Court now under Administrative Matter 1903-24. Right, how do I share? Okay, so attorneys and admissions to the bar, additional requirement for other applications. So you have to complete the prescribed courses in the Bachelor of Law. Now it has been everyone who takes up law would now and completes it would now be considered as a Juris Doctor graduate. No? Hindi ito doctoral, this is different. This is just a professional doctorate, no? Hindi siya Doctor of Laws, no? You have to still take a Masters of Law and then DCL. In law school or university, officially recognized by the government, etc., or by the proper authority in a foreign jurisdiction where the degree is granted. Okay, so in some cases, graduates of foreign law schools, no, who obtain the Bachelor of Law in the church shall be admitted to the bar examination unless he or she has completed the following courses. Yan. At saka dinagdag yung clinical legal education program. So, kailangan magli-legal aid, no? May mandatory na siya. Now, those who are who graduated from a foreign school, may mga additional requirements siya, no? So, kailangan mong mag-4th year sa Philippines, no, to be able to finish it. So, these are additional requirements, no, in the admission to bar, no. Aside from, you have to have a clean record, ano ka dapat tawag dito, meron ka dapat good moral character, etc. No? Now, I hope all of you, or if not most of you, would later on consider taking up law, no, for your best interest. Now, before moving forward, I forgot to touch on. I'd like to pose a question, rather. What about in the advent of information technology? Can publication in the internet be considered as a mode of making the law public, of publishing the law? Can it be a mode of making the law known to the public? And if so, does this meet the standards under the new Civil Code for the Effectivity of Law or of Laws? Now, while the internet, the information technology is an avenue for purposes of enforcing a law or informing the public of the existence of a law, this mode, however, is not one of those provided by the Civil Code. The Civil Code limits the publication to either the official gazette or a newspaper of general circulation. And in the case of Scenarillos, the standards for publication or of a newspaper of general circulation has been emphasized, no? So more or less numerous subscribers, no, within a particular jurisdiction, etc. So ganun lang. Uh, uh, Kasi sometimes it takes forever, no, before a law is published in the official gazette. So right now, it's still print. No? Now, if and when Congress legislates at a later time to include in the term publication online publication, do you think that would suffice if that law is implemented? Or would the Supreme Court struck this down for being violative of the new civil code? Well, it remains to be seen, however, given that not everyone still has access to the internet, that may be a question along the way. No? Although a great number of Filipinos clearly now have access. So unless probably the government is able to provide free internet access to all, then maybe if that happens, it could now be justifiable to say that everyone may have access to it. No? But absent any showing that everyone has access to the internet, this would surely be challenging. Now, let us also take a look at some of the other items that have not been discussed. No? Now, in terms of the hierarchy of laws or the distinction between among the Constitution, statutes, and ordinances, etc., no, take note that the Constitution is the supreme law of the land. All other laws, ordinances, and rules. But by the way, the requirement for publication covers all, even rules implementing this law. So there's no exception. Unless it's just an advisory or doesn't really vest any penalty or any sanction, but otherwise all must be published. So between and among these, the Constitution serves the supreme law, and all laws, ordinances, rules must be subordinate. They should follow the Constitution. So between the Constitution and these other laws, the Constitution prevails. Now, there is a hierarchy there, no? So when it comes to ordinances on the other hand must subscribe to statutes, no? So ganun yan. So, of course, our sources of laws in the Philippines is not only limited to statutes, but also it also includes case laws or decisions of the Supreme Court, no? But take note that although under the Civil Code, the judicial decisions interpreting the law of the land shall form part of the legal system. Those that interpret the law of the land is only the Supreme Court decision. So decisions of the lower court theoretically it's not covered by this the coverage. No? Only decisions of the Supreme Court in fact establish what we call as jurisprudential teachings. Yung mga Court of Appeals, are they binding to all lower courts? Well, decisions of the Court of Appeals in its appellate jurisdiction may only be binding to that particular case that they heard or that was heard by them. Otherwise, it's not correct to say that all decisions of the Court of Appeals are binding towards the lower courts. It is only the Supreme Court. So in the hierarchy of courts, Supreme Court, Court of Appeals, and Sandigan Bayan, Court of Tax Appeals, and Regional Trial Court, and then Municipal Trial Court. Hindi mo pwedeng sabihin na lahat ng decision ng RTC bound ang MTC. only that particular case. So if there is a case between A versus B, na-appeal sa RTC, naging A versus B pa rin, and then C, Court of Appeals, A versus B pa rin, yung decision ni Court of Appeals bound yung particular court that heard it. But ultimately, when it goes to the Supreme Court and the Supreme Court decides on a question of law, then this question of law now becomes a guidelines for all courts. Why? Because these are the only judicial decisions that apply to them. Now, of course, legislative procedure, we've discussed that, no? Now, constitutional test in the passage of a bill or ordinance, well, there are many grounds, but it has to be, as I said, the Constitution prevails over all laws. So unless you find a violation in the Constitution, it's very difficult to challenge the validity of a law. Now, in many cases, on the grounds of violation of due process or even on grounds of vagueness, no? Kasi kung vague yung law, paano mo ma-interpret yun? So, may violation sa due process yan. Kasi hindi malalaman ng taong bayan kung what this law is all about. So, if hindi nalaman ng taong bayan yung laws na ito, this would pose a serious challenge, no? As to how laws are to be interpreted, no? Now, parts of a statutes, kinds of statutes, well, the usual, no? I just invite you to go over that, no? Statutes normally has the title and the body, no? The penalty clause, the proviso or the exceptions. You will thoroughly discuss this when you go into statutory construction. As to the kinds of statutes, well, there are a variety of them. Laws can, for instance, be directory. As to enforcement, it can be directory, mandatory, or discretionary. Well, mandatory is it compels you to follow it. Prohibitory prevents you from violating it, and discretionary, you may or may not, no? Now, as to the period, well, take note that laws are repealed only by subsequent ones, and the non-use or misuse as a rule is not a ground. But again, in statutory construction, you will see that there are doctrines or doctrinal teachings, no? For example, a law was made during a martial law where there is this intention, but martial law was eventually lifted, wala na yung intention, wala na rin yung law. So may mga ganong instances. Or of course, if the law is self-expiring, bawa yung rent control law. Rent control law was repeatedly extended, no? Kasi it only addresses a certain period, automatically wala na yun. Pero in the absence of that, the law would still continue. So take note of those, no? As to enforcement, the other item, positive law versus equity. Well, generally, when you talk of positive law, these are laws legislated by Congress. But however, if there are no laws that apply, so the law on that is where the role of equity comes into play. So courts are, well, while it is correct to say that we are a government of laws, not of men, but in some cases, when there is absence of a law that would directly address an issue, courts as a court of equity will come into play. Courts will have to take into account basic common human standards, no? And then apply it. If it would be necessary to temper the the application of certain instances. So, doon papasok ang equity under the circumstances, no? Now, well, before briefly going into how legal research is to be done, well, as an advocate of the law, I would invite you to if you have time. So I have a number of discussions about a variety of laws over the many years of my practice, and as a practicing attorney. So I am one in I have been very active in sharing my advocacies with the law, no? So I mean you can visit my page, the Pinoy Street Lawyer. It's a Facebook page where I share some insights about the law. I put or I share these advocacies to the public, and even to a certain extent, no, I provide even free legal advice to those I really see that need advice. So this has been my advocacy, and just to share with you some of my advocacies visually. So I also have this Instagram on Pinoy Street Lawyer that you may also visit, no? So well, this is just an example of some of my advocacy. So this was yesterday, so I met with one of the active lawyers, no, in the industry, and well, in court we would normally slug it out issues, no, but at the end of the day, the lawyers can also settle cases, no? Now, aside from that, if you'd like to see how courts are, how we do it now in the new normal, how we lawyer, how we implement the law. So as you can see, well, you have to observe all court protocols, no? So now, well, right now, it is seemingly normal, but it's not yet normal. So this is how crowded courts now are, no? Lawyering in the new normal would also be online. So this is sometimes how we do it, no? And this is an example of an online hearing. Sometimes we do it in court, and sometimes we do it virtually. So this is also some of the so this is how you do it. This is part of lawyering. Now this is in the National Labor Relations. This is about labor laws. This is how this is the level of toxicity when you go to court now. Even before, that's how long lines are. No? Well, by the way, I also is an avid biker, so that's part of my advocacy. So this is how hearing are mainly done, and as you can see here, well, the prosecutor is a friend of mine. He took a picture and sent me a copy. So you see how protection are done so that the judges will not be affected, no? So ganyan ang as if the lawyer can go beyond that point. Well, there's a harang. Okay, so this is from offsite online hearing to on-site hearing, because I think in this particular day I had an online hearing in the same court. I had an online hearing in the same judicial region but different court. Yung isa offline, yung isa online. So I had to do it in a day. So as you can see, I really am an avid biker. So yan. So this is also part of lawyering. No? Here I was about to conduct my cross-examination on a witness, and just to give you a bird's eye view, this is how you do it. You raise all your objections early on. Also, another part of lawyering and seeking to enforce the interpretation of a law. So this is how we conduct it when you have documents that you need to compare. So this is how it's being done. Now this is the current state of the Hall of Justice. That's where courthouses are found. Each and every city has its own it has its own justice hall. So ganyan ka-stricto sila. You have to get first, no, some clearances before you can get in. Well, yan. Madami pa ring meeting, That's why, by the way, you really have to stay healthy in this new normal, especially for us. We are exposed. So I have meetings everywhere, and I have hearings also everywhere. So, and I also bike everywhere. So, and, well, of course, this one I am also involved in the some calamity fund drive. But if you would read what I posted here, which is also related to law, if a natural disaster is occasioned by human negligence, the act of God becomes an act of man. The act is deemed humanized. The principle embodied in the act of God doctrine strictly requires that the act must be done when occasioned exclusively by the violence of nature, and all human agencies are to be excluded from creating or entering into the cause of the mischief, when the effect, the cause of which is to be considered, is found to be in part the result of participation of man, whether it be from active intervention or neglect or failure to act, the whole occurrence thereby humanized. Now this, I just echoed the ruling of the Supreme Court in NPC versus CA. So by calling on to be gentle to nature, and at the same time for Congress to really address this, no? Kasi yung negligence nila in either coming up with measures that should prevent the abuse towards nature, as well as yung mga laws, no, yung negligence sa pagkukulang sa pag-announce ng release ng mga dam. I think this became the proximate cause while we suffered this delubyo anew. So well, again, this is part of advocating the law. So when you become lawyers yourselves, I mean, you also share whatever thoughts you have, no? So, ganyan, ano? Ganyan, naka-traffic na yun, class. Although this was just last month, ano? You could imagine now. Yesterday, the reason why it took time for me to record this, I mean, sobrang traffic, no? For me to be able to finish it, no? So part of so it's always a mixture of lawyering and the like and whatever, no. That's what I do. Now this is a virtual preliminary investigation. I do not know why they call it virtual, but we are required to be present. So but this is actually done outside the office now. They don't allow us to come in. So, and they call it virtual or whatever it may be worth, no. So here I still provide advice, no, but of course lawyers do better when they provide legal advice rather than relationship advice. These are a couple, no. Okay, now this is one of my advocacies. So I do downhill. No longer part of lawyering, but bundok yan. Well, bottom line, class, is that as lawyers, or even if you have careers that you'd like to focus on, you should not stop yourself from doing what you love to do. You shouldn't stop from exercising your passion, and I found this passion just recently during the pandemic. So rather than burying myself with negativity, I tried to be positive, and I tried to bike, no. Again, so different courts have different protocols that they observe. Now this particular judge, well, although she allowed me to have a selfie, no, that's how she requires, no. So meron ng takip sa paa, may takip, actually may gloves pa yan dapat, no. So this is lawyering in the new normal, no? So pati yung mga courts, no, talagang mahirap, no. So more or less makikita nyo, pagka mas madaming bike, mas luma pa yan, pero may mga hearing pa din, ano. So yan, no. Even as last week, no. Yan, this is also lawyering in the new normal. Of course, I am providing advice cross-border. These are Americans, no. So yan, ganyan, ano. This is in the province. So iba-iba silang klase ng protocols, no. Yan. This one is in supposed to be a hearing in Bataan, ano. So pero virtual, so that's fine. So online, ganyan pa rin, ano. You see how so even the past months, no, ganyan ng lawyering natin. So I have been an advocate of the law since I became a lawyer. So I reached as far as Kagsawa ruins. Even sa shotgun, yan. That was in September. So I go up the hills, no? Yan, so halo-halo. Another part of advocating the law, of course, yan. So sometimes I do a lot of interviews. Well, you can visit the page. I posted some of the videos there relating to laws that might be of interest to you. Arrest, family law, custody, and some other related laws. You can just browse them for your information and guidance. Yan. So this is what a single dad's life is. So you either bike or you lawyer. So ayan. So, in courts you have to wear formal attire, but here pagka mga labor lang, kahit mga barong-barong is fine, no? So more or less that's about it, no? But in the old normal, ang lawyering was not as bad as Yan, this is another part of lawyering in the new normal during the pandemic. So I would also provide some guidance, no? Yan, before the pandemic. So well, yan, may mga please ignore the size, no? You may find a different me, because I started biking in March only. So ayan, this was how we used to do it. So sa mga labor issues, ganyan. So dikit-dikit pa at the time, no? These are yan, the others are lawyers. I led the team in a case before. So ayan. So so I help these people out, no? I assisted them, so at least na released sila. So this was how it's being done before, you know. Ayan, ang mga court noon, walang mga harang. So if you can look at it, no, malilinis. So ganyan, no? Even a senior citizen is required to appear in court and testify. This client of mine, well, he passed away already. Yeah. This is how we were doing it before.
Kaalis na ng bansa si Shakes, nalubos na kinadismaya ng kampo ni Pamela.
With the very swift and overly diplomatic actions of the DFA and the DOJ, to many of us, it would really appear that it is our government who lawyered for Mr. Shakes, and that is so unfortunate. Because, as I said, this could be our shining moment. Tell the world, question this Vienna Convention and insist on our law.
Depensa ng DFA, sinubukan naman daw nilang kumbinsihin ng Embassy of Panama na i-waive ng immunity.
That is a case involving criminal offense committed by foreign diplomat who was allowed to leave, no? So yan. So in the old normal, this is how it's being done. Tabi-tabi pa yung mga prisoners and all. So earlier, as I said, no, overflow of cases is the root of the problems in the judiciary. So, yan. So more or less, I hope you had an overview, no, of how laws are treated in our jurisdiction. Ganyan yan. Oh. Even in the old normal, nag-jeep tayo, ah. Ganyan naman. You have to be flexible. Or even in the old normal, oh. Nahaba ng pila. And so I hope that somehow you are able to have an overview of how laws are to be treated and appreciated. Now, when it comes to researching about the law, well, it's very important to follow the steps that are found, no? I'll share with you the link of the guidelines that you should follow, but in essence, you have to understand the basics of the law. You have to find legal resources. Resources can be primary or secondary. You have to identify the legal issues, and then using these primary and secondary sources, which can either come from the Constitution, from the statute, regulation, or then you apply this into the law so that you can validate your research, and then you put them all together and you come up with your paper. Now, there are a variety of legal of works in legal research, no? It can be a memorandum of law, no? It could also be a paper. Now, bottom line is, when you conduct your research, or even as lawyers, when you practice law, eventually, you practically do legal research all the time. And when researching, the most important item that you should focus on are just two things. It is just like taking an exam. So if you encounter an essay problem in your exams, no? The question would be, is X liable, or is the law valid or not, etc. When you answer it, just like in research, you organize an imaginary triangle. What is the imaginary triangle? So yung imaginary triangle, the vertex will represent your conclusion. So kung question siya, yes or no, valid ba o hindi, so sasagutin mo. And then yung body, yung vertex, rather yung body nung triangle represents the factual and the legal basis. So in all of the researches that you make sure that you have enough factual basis and you have enough legal basis. And using the legal basis and the factual basis, ipagbabangga nyo, then you come up with your conclusion. That would justify, again, yung nasa vertex mo. Pag sinabi mong no, X is not liable, then you will answer, why is he not liable based on factual premises? Well, he is not liable because based on the facts, it appears that the incident was prompted by a mere accident. Clearly, there was no malice on the end of the person who seemingly committed a wrong. And now, if that is the factual basis, then you will answer now the legal basis. And under the law, yan. So, for example, it's a libel. And under the law, in order that libel may be committed, it is imperative that the utterances must be made with malice. While the malice is generally presumed, if it is overcome by evidence showing otherwise, then the malice can be may not apply. Therefore, in the final analysis, X clear is not liable. So, in researching, you have to use both the facts and the law. And when you use the law, you either base it on jurisprudential teachings or the Constitution, statutes, ordinances. Now, right now, because of the advent of information technology, it is easier to ascertain ourselves with the laws that we encounter. So, ako, what do I do when I research? Talagang I first really come up with clear facts. No? Kailangan malinaw yung facts. Once I lay down the fact, then I will research on the law and see if there is an impact. Now, when researching on the law, I always pay attention to details. Ano ba yung sinasabi ng batas? And then, I look at related jurisprudence. And then, when I see related jurisprudence on the matter, then I will now conduct my conclusion. Now, as lawyers, often you will be tasked to research on legal opinion, for instance, no. Yung legal opinion, yan ang very common na anong tawag dito, na nire-require. In some jurisdictions, ang tawag dito sa legal opinion, memorandum of law, no. I'll show you a sample of a legal opinion, ano. Well, as lawyers, of course, if you are tasked to secure a legal opinion, it's good because before proceeding with whatever legal direction you'd like to take, no, ito. Ito, simpleng legal opinion lang naman to. Because I was tasked by to give a legal opinion on the administrative adoption of a minor. So here, one of the spouses is a foreigner, so they wanted us to determine the appropriate action. Now, based on the documents referred to us, direct to the point. So, do not mislead your client that things can be done. So, ito, nire-require ng batas yung 3 years joint adoption at saka 3 years residency on the administrative adoption. So, it cannot be done. So, because recently, a law was passed by Congress, yung Simulated Birth Rectification Act. So, this is like an administrative adoption. Mas mabilis na ngayon. Kaya lang, required pa rin yung residency. Ito yung mga kung pinalabas mong anak mo, tapos hindi naman totoo, pwede kang mag-administrative adoption. So, the other option that we therefore provided would be the filing of a petition for guardianship. So, here, we stated the grounds and the qualifications, And then we simply stated here that if he qualifies for that, then he is qualified. So, ganun lang kasimple, no? The other legal opinion that that I made was this one, another foreigner. So legal opinion, the criminal action. So based on your representations as well as documents endorsed to us. So in-state muna lahat ng facts. Yan, facts. Kung ano yung facts na sinabi. Mahaba. Now, with the object of proceeding with the sale and obtain the vegan title, the issues which I deem appropriate to resolve in the instance is what are the chances of criminal prosecution against those who took part in the transaction. If so, what crimes? Yan. So here, yan. So I stated what could be done, no? So forth and so on. I stated the law. And then after stating the law, yan. I tried to explain what these are. And I cited jurisprudence on the matter. Deceit, excuse, idea of mistake. So, may reference ako. American jurisprudence, revised penal code, etc. No? And then taking into account your earlier representations as well as your intention to proceed with the sale, etc., the funds that may have been employed was not subdivided will become irrelevant as the only appropriate criminal charge based on my professional judgment should be estafa, etc. Yan. Then I discussed the elements again, etc. Now, even what he raised, I will. So that's what I raised. No. Now, so what happened to this case? Well, I actually continued prosecuting this case. This opinion was made in 2006, I think. No? So, and eventually, we've succeeded in prosecuting this case. It reached up to the Supreme Court, and I got a conviction, so in favor of my client in this case. 2006. So that's how you do this research and all that. So again, if you have questions or concerns, feel free to message me either here or even on my page. I wish you all luck. It's unfortunate that we weren't able to interact as we should have interacted because of so many limitations in this new normal. But I do hope one way or the other, despite the difficulties, I was able to share substantial information and somehow impacted on your view on the law. And this would not be the first time, of course, that we would be seeing each other. I would still be around, and you can always PM me for any concern that you wish to be clarified with, especially in matters concerning the law, because I have been an advocate of the law for the longest time. And again, I thank you for taking time. And do not worry, we will be very reasonable even in the exam. It will be as easy as ABC. as it should be. In the last exams that I gave, I think you had choices, no? But ultimately, you only have to choose between true or false. Because if it's partially true, it's also partially false. There's no such animal as a partially true or a partially false answer in the academe. It's either true or false. So we likely have a choose the best answer, but we'll have to limit the tries, no, into just one. So again, maraming salamat sa inyo, and I wish you all well, and good luck as you end this semester. Again, thank you very much, and stay academically challenged, but always stay healthy and happy. Maraming salamat sa inyo lahat. Thank you.